Good morning.
Good morning.
Welcome to the 7th annual Conference on Applied Feminism, sponsored by our Center on Applied Feminism here at the University of Baltimore School of Law. I'm Ron Weich, the Dean at the University of Baltimore School of Law, and I welcome you all to our new building. Hope all of you have a chance to walk around, those who haven't done so already, and see this exciting new space in which we provide our exciting legal education. But it may be that you don't have so much time to walk around because you have a very full agenda today dealing with a very important topic. I want to commend our Center on Applied Feminism and its 3 co-directors for organizing and spearheading this very important conference on applied feminism and health. So join me in congratulating co-directors Michelle Gilman, Lee Goodmark, and Margaret Johnson for their work on this conference. All aspects of applied feminism are very important, but I think the topic of today's symposium, applied feminism and health, is especially timely and vital. Let me tell you why I think so. Early in my legal career, I had the privilege of working for Senator Edward M. Kennedy. And as many of you know, Senator Kennedy's life's work was healthcare reform. He believed that every American should have access to affordable health care. And he fought for it through many different presidential administrations, through thick and thin. I was working with him in the years when President Clinton was trying to pass a comprehensive health care reform bill. And that effort was unsuccessful, but Senator Kennedy never gave up. He understood how important community function this was, how none of us are healthy unless all of us are healthy, unless all of us have access to health care. And it pained him, I know, at the end of his life, that in this country we seem to have lost the common ground, the understanding that it was a vital and legitimate public goal to expand access to health insurance. That had been the understanding. There were good faith debates about the right mechanism by which to do it. In those days, the Republican Party favored an individual mandate. Senator Kennedy and others argued for national health insurance in the early days. But everybody agreed that this was something that the government needed to tackle. In recent years, we seem to have lost that common ground, and now there are those who say that everybody's on their own, and some are actively working to sabotage the Affordable Health Care Act, which is terribly painful. There was not, unfortunately, common ground on the issue of reproductive rights. Senator Kennedy, like many Roman Catholic politicians of his generation, actually opposed abortion in his early years in the Senate. But in the years after the Supreme Court decided Roe v. Wade, he came to understand how vital reproductive rights are in the context of overall health care reform, and he became as vociferous an advocate for women's rights, women's health care generally, and reproductive rights particularly in the last 25 years of his tenure in the Senate. This is a topic that needs to be addressed both on theoretical and practical levels, and that's exactly what you all are going to do today. I'm so impressed with the program that our center has put together to address these issues, and I know you will all find it very enlightening. And by participating in this discussion, you help move us towards that common ground that I think this country needs about the importance of healthcare, about the role of women's health care in the context of national health care reform, and especially the right to reproductive choice. Nothing could be more fundamental. So welcome, and it is now my pleasure to bring to the podium John Baber, who is the editor-in-chief of our Law Review, University of Baltimore Law Review. John is one of our star students. He is soon to graduate. He'll be beginning a prestigious clerkship with Judge Lynn Battaglia of our Maryland Court of Appeals. But in these last few months that we have him, John is hard at work on the Law Review, and he'll describe to you the role that the Law Review is playing in this symposium. So welcome, and John, please join us.
Thank you, Dean Weich. Thank you, professors, Center on Applied Feminism, and all the student attendees. I think it's a really cool sign that in these times with these hot issues, the young people here are supporting the public discourse on these issues and kind of getting the most that law school can offer them with exposing them to these issues, especially since this next generation of people like me are going to be the ones out fighting for them. So the Law Review has a real distinct pleasure of partnering with the Center on Applied Feminism in publishing a symposium issue of articles that will come out of these discussions. And it's been a real distinct pleasure for me personally, after having Professor Gilman for Evidence, to work with her as a colleague instead of fear her as a student. Thank you for that opportunity. The Law Review is at a great place to publish these kind of hot topics because of the speed and rigor of our production process. We put every article through comprehensive site checks and can get an article that's submitted to us in May published by the next December. We take great care in kind of preserving the author's voice, as well as making sure that we can put together a full issue of timely articles, and we're really concerned about getting things out there that people want to read and people want to cite to. And I think at this juncture, the public discourse on these reproductive issues is a hot topic people are talking about and want to write more about. So we're very excited to be publishing these issues, both for our journal, for the school, and for the Center on Applied Feminism. And with that, I'd like to introduce Professor Margaret Johnson, who will introduce the first panel. Professor Johnson.
Good morning. Again, welcome to the Center on Applied Feminism's 7th Annual Feminist Legal Theory Conference, Applied Feminism and Health. I'm Margaret Johnson. I'm one of the co-directors of the center, and I, along with my two other co-directors sitting down here in front, Professor Lee Goodmark and Professor Michelle Gilman, also welcome you to the conference. First, I want to thank the many people who make this conference possible. Dean Weich for supporting the conference and the center. Our conference committee, who are here and strong, and you will see many of them moderating panels today. Our amazing students from the Law Review, who are all dressed up in very professional looking suits. The students supporting the Women's Law Center, who have been an incredible partner to the center, not just for this conference, but for many events, and the Women's Bar Association. In addition, we want to thank Hope Keller and Heather Cobbett from the Dean Suite, who's helped us create the evites for this event and other materials. And most importantly, we have to thank Brittany Martinez, who inevitably isn't here because she's out there doing the incredible work that she's done, not just during the conference, but throughout the year in planning this event. And we really could not put on the event without Brittany. 7 years ago, we decided that we wanted to create a forum for scholars, practitioners, and activists to come together and share ideas about cutting-edge issues in feminist legal theory. From the beginning, we knew our project would be about applied feminism, where the intersection of theory and practice meet to effectuate progressive social change. Moreover, from the beginning, we've taken the many useful constructs from feminist legal theory, starting first with the premise of seeking justice for all people on behalf of their gender, and continuing with the recognition that any system of oppression or discrimination based on gender doesn't operate alone. None of us is solely self-defined by our gender or defined by our society based on our gender. We have other personal identity characteristics, race, sexual orientation, class, and other issues that help to define the unique person that we each are. And so from the beginning, we've ensured that the Feminist Conference and the Center on Applied Feminism is recognizing and working on dismantling all intersecting forms of oppression. And that work continues today with the conference. From the beginnings of our Feminist Legal Theory Conference 7 years ago, our Center on Applied Feminism was born. Through the center, we offer this annual conference and various symposia and colloquia throughout the year. We offer a regular feminist reading group for the entire university community. And thanks to the fundraising efforts of Professor Jane Murphy in the back, we now offer a public interest fellowship stipend for a student engaging in feminist legal work during the summer. We do legislative advocacy and client work applying feminist legal theory to practice. We engage in the broad project of helping to organize the feminist legal community, and with this, we're so happy to have the Women's Law Center of Maryland, our proud local feminist legal organization, to lead us in this endeavor. And Tracy Brown, the executive director of the Women's Law Center, is sitting in the back, and they helped to co-sponsor the workshop we put on last night. In addition, the Center on Applied Feminism mentors students in a variety of ways who are interested in pursuing feminist legal work. Last night, the conference began with this incredible workshop I just mentioned on reproductive justice issues, with speakers from the Center for Reproductive Rights, the Guttmacher Institute, Planned Parenthood of Maryland, and NARAL Pro-Choice Maryland PAC. And then we heard from Terry O'Neill, the president of NOW, who provided the keynote address emphasizing the importance of ensuring voting rights, especially for unmarried women. Many of our community members in this room fit that demographic, and what Terry O'Neill said was that engaging unmarried women to vote can make a huge difference regarding what policies get enacted in legislatures around the country, both locally and nationally. And today, we're thrilled to have such an impressive array of speakers presenting their papers on such varying topics as reproductive rights and religious liberty, hospital breastfeeding, sex selection, and the Affordable Care Act. So let's get started. I'm going to ask the first panel to come, please, get seated. And I will introduce Christine Spencer, who's a well-regarded professor in UB's College of Public Affairs, a member of our conference committee. She will be moderating the first panel, which is entitled Assessing Competing Claims of Rights Under the Affordable Care Act. Now we'll turn it over to you, Christine. Thank you.
So as Margaret said, our first panel is called Assessing Competing Claims of Rights Under the Affordable Care Act. And we're going to specifically look at how we think about the health law when rights conflict with one another. And specifically in the case where we have religious rights conflicting with reproductive rights of individuals. And this is especially important because the Supreme Court will be hearing this spring, and so we're very interested in all of the perspectives that our panelists have brought to the issue. But first, from my point of view, it's worth remembering why we have a contraceptive mandate in the health care law to start with. The Institute of Medicine was asked to provide recommendations to the Obama administration on what preventive services were important to include. Their criteria included these services must have a large potential impact. Thought I was projecting so loudly that everybody across the wall could hear me. Anyway, so the criteria that was used by the Institute of Medicine for inclusion of preventive services in the healthcare law was that there must be a large potential impact on the health and well-being of a broad population, and that these impacts were supported by strong and high-quality evidence. These are interventions that work, that have been proven to work, and that need to be accessible to all people. That's why they're in the law. Just wanted to point that out. There's a compelling interest in having these preventive services of all kinds. So as a non-lawyer and a public health person, I guess I tend to overlook some of these other competing interests because for me it's about what's right and what's right for our country in terms of promoting health. It's been very educational for me to be involved in the reading of these papers because it's opened my eyes to the issues that I really, really would not have ever understood had I not read your papers, which were great and very, very helpful to me in thinking through some of these issues. If nothing else, it's made me even more convinced that our antiquated system of having employer-based health insurance is really got to go because it's not concerned about the health of the population. It's much more concerned about some of these other interests that you address. So thank you for educating me in that way. But you as lawyers have a more difficult job in actually working with the law as it exists and determining how these rights should get determined. So in this case today we're going to be looking at comparing the rights to religious freedom, an important right, with those of reproductive rights. Our three panelists will each address this from a different point of view. We have about an hour and a half to figure this out, so I'm going to get started on that. Each panelist will have approximately 15 minutes plus or plus. I will first introduce them, and then we'll just go down the line to hopefully leave enough time for questions at the end. Our first speaker is Jessica Waters. She's Assistant Dean for Undergraduate Education in the American University School of Public Affairs. She's also an assistant professor in the Department of Justice, Law, and Criminology. Her research focuses on reproductive rights law, exploring questions related to state control over reproductive health care and women's access to such care. Dean Waters and her co-author, who's in the audience here, Leandra Carrasco, they examine how courts evaluate the religious liberty claims of employers when those claims compete with the employee's interest in being free from gender discrimination. Now, if I botch any of the legal aspects of this, feel free to correct me when I summarize what I think you're driving at. Next, we'll hear from Caroline Mala Corbin. She's a full professor at the University of Miami School of Law, and she's a well-published author in the New York University Law Review, UCLA Law Review, Northwestern University Law Review, and Boston University Law Review, among many others. She's very accomplished in this area. Professor Corbin looks at the issue of whether for-profit corporations have a right to religious liberty, especially after the Supreme Court's ruling in the Citizens United case, which recognized the right to free speech. If I ever go to church and I find myself sitting next to a corporation, I'll be surprised. But so I'm very interested in what Professor Corbin has to say about this issue. And finally, we have Cara Loewentheil. She is currently a postdoctoral associate in law and fellow at the Yale Law School, affiliated with the program for the study on reproductive justice at the Information Society Project at Yale Law School. And beginning in May, she will be the project director of the Public Rights, Public Conscience Project at the Center for Gender and Sexuality Law at Columbia Law School. Finally, Ms. Loewentheil focuses on burdens created by the Affordable Care Act contraceptive mandate on both the for-profit corporation religious objectors and on the employees as third-party existing rights holders who risk losing these benefits of the contraceptive coverage should the courts decide for the corporations. So with that, I'm going to turn this over to our first panelist, and I will be the timekeeper from now on. Thank you.
Good morning, everyone. Can you hear me in the back? Are we good? Okay. Yes? Thumbs up. Okay. I was asked to give a brief overview on behalf of the panel about the Obamacare, right, and the Affordable Care Act and the contraceptive mandate, contraceptive coverage requirement. That could take about 16 hours. I am attempting to do this in about a minute and a half, so excuse the brevity. When we talk about the Affordable Care Act, the ACA essentially sets minimum standards for group health plans, saying this is what you have to cover, minimum, right? Plans can certainly choose to go beyond that. And included in the ACA throughout the wrangling, at the congressional level over the past couple of years, there are provisions that say certain preventative health care services have to be covered. And that makes sense, right? Because we want to prevent certain diseases and conditions from happening before they start, because it's more expensive to cover something once you're actually sick, right? So things like cholesterol screening and screening for diabetes, so you can, cut things off before they get too bad. Included in those preventative health care provisions are provisions about women's health. And again, this also makes sense. So things like screening for certain types of cancer or breast cancer screenings, right? Those things are included in this preventative health care services provision. As part of that, there were questions, as you can imagine, about what that means. When we talk about women's health, what is the range of services that has to be covered? And the Health Resources and Services Administration, which is part of HHS, was charged with coming up with guidelines about what this means. And they received guidance from the IOM, the Institute of Medicine, to define what we're talking about when we're talking about women's health services and contraceptive services. And the guidance that came down and has the force of law through the regulatory process is that contraceptive methods and counseling must be covered by these group health plans. And contraceptive services is defined as all FDA-approved contraceptive methods, sterilization procedures, and patient education and counseling for all women with reproductive capacity. That's when we say the contraceptive mandate or the contraceptive coverage requirement, that's what we're talking about, right? So the law now says you have to cover all forms of contraception that are approved by the FDA. Now, let's be clear, when we're talking about prescription contraception and we're talking about contraceptive methods covered by the FDA, we're talking about things that women use, right? We don't currently have contraceptive, prescription contraceptive devices for men, right? We have vasectomies, but that's a different thing, right? So when we're talking about contraceptive coverage, when we're talking about Plan B, we're talking about things that women use. Long story short, there's also an exemption and an exception to this contraceptive coverage requirement. And there's an exemption for religious employers, and it's fairly narrowly defined to include churches and associations of churches. It tracks the IRS definition of what a religious employer is. And because of some of the political wrangling, there's also an accommodation. And the accommodation allows certain non-profit organizations that are religious in nature to essentially self-certify that they are a religious organization that opposes coverage for these contraceptive methods. What's important for our purposes is that both the exemption and the accommodation only apply to nonprofits. They don't apply to for-profit agencies. And that's what sort of gets us to the Supreme Court. Because what we see at the court now, or at the Supreme Court now, two cases dealing with for-profit entities who say, I'm a religious employer, but I should still get this contraceptive, not have to comply with the contraceptive coverage mandate. So they are challenging the mandate in its entirety. There are another dozens of cases winding their way through the lower courts where we have nonprofits are saying, wait a minute, I should qualify for this accommodation, right? So we have two sets of cases. The one before the court now is a specific question of these for-profit corporations who can't get the exemption sort of no matter what. Does that make sense? The following? Okay, that is the ACA in 2 minutes, okay? What's interesting, I do have to note this. So Hobby Lobby is one of the primary parties before the court saying, you know, we are a religious employer, we're for-profit, we don't want to cover these contraceptive methods. What's interesting is before the ACA and the contraceptive coverage provision went into effect, they were covering it and apparently just didn't know or didn't care. And only after it went into effect did they go back and say, oh, wait, we're covering this. We're going to take these things out. We're going to selectively pull out contraceptive methods from what we cover, and now we're going to challenge the law. So, interesting side note. So that brings us to our paper. The challenges before the court right now are teed up under the First Amendment and the Religious Freedom Restoration Act. We call it RFRA, right? And the fundamental issue there is we have corporations saying that corporations are people that have religious rights. I am not attempting to tackle at all whether corporations are people. My paper does not address that. I leave that to people smarter than me. What we're focusing on is how do we balance reproductive rights and asserted religious liberty rights. And for purposes of my paper, I'm not accepting corporate personhood, but I don't address it. So there's a little footnote that says, well, we do not accept corporate personhood. It is not addressed in this paper. The Religious Freedom Restoration Act essentially says that the federal government cannot burden a person's exercise of religious rights, so substantially burden a person's exercise of religious rights unless there is a compelling state interest to do so, right? And that's the key. What's a compelling state interest? And when we started thinking about this paper, we started thinking about, well, how do you make the argument that reproductive rights are compelling and gender equity is compelling, right? And our law students in the room know when we think about levels of scrutiny, right? When we think about race or gender, we know gender gets intermediate scrutiny or sort of intermediate plus if you look at US versus BMI, right? And we know that the court has said that the right to privacy is fundamental. But there's some tension there when we're talking about balancing that against an assertion of religious liberty, right? And the question is, how do you balance that? And we started thinking sort of at once more narrowly and more broadly about, well, how do you do this outside of the ACA? And started looking at Title VII cases. and specifically looking at Title VII cases where a religious exemption was asserted in the face of a claim of gender discrimination. Because there's a parallel there, right? When we're talking about exemptions from laws that prohibit some form of discrimination. And I would argue that's what the contraceptive mandate is about, right? When we're talking about the contraceptive mandate, we're talking about saying to employer-based health plans, it is not okay, right? It is discriminatory to exclude coverage for a class of preventative services that only affect women, right? That is a claim of discrimination. So we looked at the parallels to Title VII cases, and specifically, there have been a series of Title VII cases at religious schools. So you have female employees working at, for example, a Catholic school. And they're teaching things like science or language arts, right? They're not teaching the religion classes. And they, the female employees get pregnant, or they're attempting to get pregnant, and they're fired for that, right? I hope when you hear that you think, wait a minute, don't we have a law that prohibits that? And of course we do, right? And that law is Title VII. Title VII is our federal civil rights law that prohibits employment discrimination on the basis of race, sex, religion, national origin, color, and included under this prohibition against discrimination on sex is a prohibition against discrimination based on pregnancy, right? So Title VII was amended in 1978 by the Pregnancy Discrimination Act, which made clear that sex discrimination includes pregnancy discrimination, right? If you fire someone because she's pregnant, that is sex discrimination, right? And that has been made clear and codified in federal law. Where it gets tricky with Title VII is that Title VII has an exemption for religious employers. And you can imagine how this would work, right? You don't want to say to a church or a synagogue, you know, you have to hire someone who doesn't share your religion to teach other people about religion, right? Or to be a minister. So there's an exemption in Title VII for religious organizations. Where it gets even trickier, however, is this. This exemption allows religious employers to discriminate on the basis of religion. It does not allow them to discriminate on other protected bases. So for example, you cannot be a religious employer and say, well, I'm a religious employer and part of my religious belief is that I don't want to associate with African American people. Therefore, I will not hire anyone who's African American, right? That does not fly under Title VII. You can discriminate on the basis of religion, but not on the other protected bases. However, if you have a religious organization that says, well, part of my religious belief is entangled with beliefs about gender and reproduction, the courts really don't know what to do with that. So it raises the question of, how do you balance the competing interests when the asserted religious discrimination is entangled with questions about gender and reproduction, right? Because gender, reproduction, and religion, there's this conflation, right? You're very rarely going to hear someone argue, for good reason, that your religiously inspired beliefs can justify race discrimination. But we do hear that your religiously inspired beliefs can justify sex discrimination and pregnancy discrimination, right? Because sex, people engaging in sex, and the effects of sex, right, pregnancy, are seen as moral issues. And we argue that this reframing and this recasting is problematic. And we see it in Title VII cases, and we're seeing it with the ACA cases. So I'll give you some examples. There are two fairly recent cases just in the past 2 years. There's a case called Diaz out of Ohio. And there's a woman who was using IVF to get pregnant. And her employer found out, and she was fired because she was using IVF to get pregnant. There's a prior case called Boyd where a woman was fired for her unplanned pregnancy. And her employer found out because she was pregnant, because guess what? It's visible when you're pregnant, right? Can't hide that. And she was fired for being pregnant. There's another case called Herx out of Indiana, married woman who was using IVF in an attempt to get pregnant, asked for some time off to go through the IVF procedures, and was fired for attempting to become pregnant even while married, right? Now, and I say even while married because that matters to the religious employers, right? In each of these cases, what we see is the employer asserting that the non-discriminatory reason for the firing was the employer's morality clause, right? Or the religious, religious or moral persona that we want our teachers to be role models, right? What we don't see is any recognition that we're not talking about morality, we're talking about the fundamental constitutionally and statutorily protected right to be pregnant and not lose your job, right? So we argue that there's a framing issue here, and framing matters, right? And I always think about this in terms of, remember the case Bowers versus Hardwick, right? The precursor to Lawrence versus Texas, dealing with laws that criminalize same-sex sodomy, right? And using their words. In Bowers, the court came to a radically different conclusion than it did in Lawrence versus Texas. And it's interesting the way the court framed the issue, because the way the court framed it was, is there a constitutional right to practice homosexual sodomy, right? That obviously was not the real issue before the court, right? We had an equal protection issue and a privacy issue. But when you frame a question in a certain way, you know what the answer is going to be, right? It wasn't shocking that that law wasn't struck down in Bowers versus Hardwick. We see that same framing issue here. The courts are not asking the question of, does this morality clause run afoul of Title VII? They're only asking the question of, did this employee violate the morality clause, right? So they're never getting to that fundamental issue of, is the policy a problem in the first place, right? And I pulled out a quote from some of the, in the Herx case, it's still ongoing, it's still moving through the courts, but the employer argues, critically I think, that this is the way the court should be framed. It says, it makes no difference that Herx, the employee, claims she was discriminated against on the basis of her sex or pregnancy status. It cannot reasonably be disputed that the basis of the decision not to renew her contract was religious. The issue is not her sex or her pregnancy status, but only the specific medical procedure, the IVF, prescribed by church teachings, right? And that blinks reality, right? You can't say, we're firing you because you're trying to engage in sexual activity or get pregnant out of wedlock, right? Or use IVF or become pregnant when we don't want you to be pregnant, and then say we didn't fire you because you got pregnant or because of your sex. And it blinks reality to say that this is not sex discrimination because only women bear those visible signs of becoming pregnant, right? So the connection in our mind to the ACA is this. When we see what the lower courts are doing, we see what the 10th Circuit does, for example, in the Hobby Lobby case, there is virtually no discussion of what the actual burden on female employees is, right? What we see instead is, particularly the 10th Circuit, characterizing any burden that would be placed on employees who were not covered under the ACA as a mere economic burden. And we see them saying, well, employees can make choices to purchase contraception on their own, or they can make choices underlying, the court doesn't explicitly say this, but I would argue that it's implied. You can make choices not to engage in sex, right? So we see this same sort of reframing and recasting of the reproductive right as a mere economic choice, or a mere choice that should be equated only to a morality clause in a contract for the Title VII cases, or an economic burden in this case, right? What this framing does and this recasting does is ignore that what we're really talking about is a burden on a fundamental reproductive right. Right? It recasts the issue of contraception not as one of it is discriminatory not to provide it, right? But as one of, well, you can make an economic choice to get it another way, right? It ignores what contraception means for women, right? It ignores that the ability to control your fertility and when and whether to get pregnant affects your economic decisions, right? Affects your work decisions, affects your education decisions, right? That is left out of the discussion almost entirely. And I would argue the government in its briefing has left that out of the discussion in its entirety. The amici have done a wonderful job addressing that point, but that's not the issue that's being placed before the lower courts or, arguably the Supreme Court right now. So in looking at these cases, and comparing them to these Title VII cases and the exemption cases, framing matters, right? Framing matters a lot, and how we talk about the reproductive right matters. If it's recast as, well, you just violated the morality clause, so that's what we need to talk about, you have put the religious liberty assertion so far above any claim of pregnancy discrimination that there's no way you're ever going to win, right? With these ACA cases, we see the same thing, right? If the only thing we're talking about is, has the corporation's religious liberty been violated, what we're not talking about is what happens to the women whose contraceptive devices are not covered, right? So we see an imbalance, and we argue the need to reframe the way we talk about all of these issues. I'm supposed to stop now. All right.
Thank you. We're just going to go down the line.
So first, I want to thank everyone who's made it possible for me to be here today. I very much appreciate it. And thank you also to Jessica for providing an overview of the two cases before the Supreme Court. My thesis is straightforward. The question I have set out to answer is, do for-profit corporations have the right to religious exemptions? And my answer is, no. For-profit corporations should not and do not have the right to religious liberty exemptions. And to be clear, I'm focusing on the claims of corporations as corporations, not the owners of the corporations. Their claims should also fail, but for different reasons. Okay. Whether for-profit corporations are protected by a constitutional provision like the Free Exercise Clause depends not on whether the corporation is a person, but on what the clause is meant to protect. So after all, despite bestowing personhood on corporations, the Supreme Court has not held that all constitutional provisions reach corporations. So the real question is, why do we protect religious liberty? And given those reasons, does it make sense to extend religious liberty to corporations? So why do we protect religious liberty and religious conscience? Well, religiously inclined people might argue that we protect religious liberty so that people can fulfill their obligations to God. Right? These duties are paramount. A person's soul could be at stake. The government should not interfere with these obligations. A more secular justification might focus on honoring individual liberty, individual autonomy and dignity. These are sort of touchstones of constitutional rights. Right? You don't need to agree with someone's religious beliefs in order to conclude that there's value in respecting her decision to follow them. So religious liberty protection furthers individual autonomy and dignity by recognizing people's rights to make decisions about their spirituality. Either way, this constitution protection only makes sense when applied to actual people. Right? The religious justification is about protecting the relationship between, well, Madison say man and his creator, I'll say woman and her creator. Right? People suffer when they cannot fulfill their obligations to the divine. Corporations, of course, don't sit next to you at church. Right? They're not sentient, they can't feel anything, they have no sacred relationships, and they certainly do not have a soul. As for the secular justification of respecting autonomous decision-making, that's grounded in the idea that all human beings possess an inherent dignity, and that respecting people's religious beliefs is very much about respecting the sort of inviolable dignity of the person. So while people are end in themselves, and people have inherent dignity, corporations do not. Right? Corporations are not an end in themselves. They're a means to an end. They're legal fictions created to facilitate economic growth. And these instrumental entities don't possess any inherent dignity that needs to be respected. In short, the reasons we protect individual religious conscience just don't apply to corporations. Corporations are not people. They're not like people. They lack fundamentally human attributes, whether it be a relationship with the divine or inviolable dignity that justify religious liberty rights. Oh, but what about religious institutions? Right? Corporate religious liberty proponents argue that since religious liberty protection extends to non-profit corporations like churches, then for-profit corporations should likewise be protected, as they are the same in all important respects. They're both religious institutions through which people practice the religion. Actually, it's only well established that churches are protected by free exercise, and the justifications and appropriate scope of free exercise protection for churches is actually hotly contested. One view is that any protection for churches is derived from protection for individual members of that church. This view, that all religious liberty is ultimately rooted in individual rights, offers little support for corporate religious liberty. But even assuming there should be protection for churches, as institutions, the reasons we protect churches don't apply to for-profit corporations. Right? One argument for protecting churches is that they're sacred, right? The house of God. For-profit arts and crafts stores and other corporations are not. Right? Another is that churches are crucial to free exercise and religious liberty because they're the sources of, there's where religious beliefs develop, they're the sources of theological truth. Once again, arts and crafts stores, not so much, right? The practice and promulgation of religion is the overriding purpose of churches. Again, that's obviously not true for for-profit corporations. By definition, for-profits exist to make money. Otherwise, they would be non-profit. Okay. Finally, free exercise protection for churches assumes that the church is an association of voluntary members. This assumption that the church is a group of people who voluntarily join together to pursue religious goals is highlighted in the one free exercise case where the Supreme Court granted a religious exemption to an entity rather than to individuals. In that case is Hosanna Tabor Evangelical Lutheran Church and School. And in that case, the Supreme Court upheld the ministerial exemption. This basically gives churches immunity from discrimination suits brought by their ministers. Now, in justifying this exemption, the Supreme Court emphasized the voluntary nature of the ministers' association. It's permissible to exclude ministers from anti-discrimination law because they have voluntarily consented to the church's rather than the state's adjudication of their employment disputes. For-profit corporations, however, are not voluntary associations the way churches are. Right? Employees are simply not members of a corporation the way they might be members of their church. People join voluntary associations because they agree with the principles of the association. People take jobs because they have to. Right? Now, you could argue that while employment itself may be an economic necessity, employment at these particular corporations are not. But this claim is neither empirically supported nor is it likely to be. Again, the reasons churches are afforded free exercise protection, that they're sacred, that they're the source of theological truth, that their overriding raison d'etre is the advancement of religion, that they're voluntary associations, none of these apply to for-profit corporations. But wait, what about Citizens United? Right? Citizens United doesn't change the landscape. So many courts and commentators have argued that since for-profit corporations have free speech rights under the First Amendment, it follows that for-profit corporations have free exercise rights under the First Amendment. Actually, it doesn't follow at all. Citizens United, or really Bellotti, the case on which its arguments are based, protects free speech not for the sake of speakers, but for the sake of audiences. In other words, corporate speech was not protected in order to vindicate corporations' right to speak, but to ensure audiences' right to information, whatever the source, including corporations. So imagine a computer was able to generate from raw data all kinds of statistics that was really important for an upcoming election of some kind. A court's conclusion that the government can't censor distribution of that information would not be based on the computer's right to speak, right, but on citizens' right to receive that politically useful information. And this audience-based free speech justification for protecting corporate speech has no counterpart in free exercise jurisprudence. And all Supreme Court precedent is really consistent with this view of religious liberty that I'm describing to you. Right? The Supreme Court has never held that a for-profit corporation can bring free exercise claims, never mind that they're entitled to a free exercise exemption. Now, supporters of corporate religious liberty point to a line of cases, actually two cases, where free exercise claims are brought by business owners. Right? So there's business owners, corporations, but the claims were brought by individual people, right? Not the corporation. And furthermore, they were rejected. And in rejecting the claims, the Supreme Court really underscored the inappropriateness of granting religious exemptions to employers that impose on their employees. So in one of the cases, U.S. v. Lee, the Supreme Court wrote that when religious followers voluntarily enter into the commercial activity, they have to follow the rules that apply to that commercial activity, like, for example, providing contraception. Okay, that wasn't in there, I just added it. All right. Furthermore, to grant employers a religious exemption from employment laws would be, and this is a quotation, to impose the employer's faith on the employees. Which leads me to my last point, which is that recognizing corporate religious liberty privileges already powerful corporations over their employees. Right? Today, okay, so what does that mean? First, it opens the doors for corporations to seek exemptions from laws that are meant to protect employees. Right? So if Hobby Lobby can deny contraception coverage, does that mean a Jehovah's Witness corporation can deny coverage for blood transfusions? Right? Will corporations that oppose same-sex marriage be allowed to deny health care benefits they otherwise provide to spouses? Right? What else might they challenge? And you know they will. Right? This really opens the door for corporations to challenge all kinds of laws that protect employees. And second, corporate religious liberty will come at the expense of employees' individual religious liberty. Something that's completely overlooked in all these cases is that religious obligations can point towards contraception use as well as away from it. So, for example, some people believe that you should not bring new life into the world unless you're able to sustain it in accordance with God's intention for the life to be fulfilled. Granting an exemption from the contraception mandate to corporate employers will make it that much harder for employees to meet their own religious obligations. In short, recognizing corporate religious liberty will exacerbate the power imbalance between employers and employees, and it really risks making religious liberty yet another luxury reserved for those at the top. To sum up, right, it does not make sense to grant corporations religious liberty. There's no precedent supporting corporate religious liberty, and corporate religious liberty will exacerbate the inequality between powerful employers and their employees.
Thank you very much, and we're on time, so go ahead.
I've begged an extra 2 minutes. Carolyn's was a little bit short. I'm going to...
Short. Donate your time.
I'm going to donate, that's it, that's right. She's going to graciously yield me her 2 minutes. It's going to take me that long just to get this going. Okay, so do I need to do anything to get this? We had it set up ahead of time. Okay, I think someone's coming down. Okay, great. So I want to thank the organizers of this conference first, as everyone has. It's so great to be here. I came last year, and it was one of the first conferences I went to as a fellow, and it was such a warm and welcoming environment. I had a long conversation with Lee at dinner last year, and so that's just really great, and I want to particularly thank the conference organizers for fostering that kind of environment. I actually grew up in Baltimore, so it's nice to be back. Yep. And you even get gift bags. It's like being at a bar mitzvah. So, a little religious humor for the religious free exercise. So y'all are my guinea pigs for my first Prezi, and I apologize. And if you get motion sickness, then I really apologize, and you might want to move to the back of the room. So as you can see, in this very large font, this is the title of the paper that I'm going to be talking about. And I think that one of the things you can see on this panel is that there are a lot of different legal registers in which you can try to get at the same problem that you're trying to deal with, which I think for all of us is, what do we do about the fact that religious exemptions may have unintended or intended consequences on other people? And so my take on it is sort of half critical legal realist and then a little bit of doctrine at the end to try to not seem so kind of counterproductive. So let's see if I'm going to stand also. I feel like you sit so much at these conferences. All right, so this is my core contention is that free exercise doctrine is ill-equipped to recognize and value harms that religious exemptions for believers can impose on third parties. I don't like the term third parties. I'm going to talk in a minute about the term I use instead. But just for now, so we all know who we're talking about, not the government, not the person bringing the lawsuit who wants the religious exemption, other people. But we can still do better than courts have done thus far. So all hope is not lost. So I'm going to use the contraceptive coverage requirement as my case study, which has been covered. And this is just a little roadmap. We're going to do a few facts. We're going to do cliff notes on religious exercise. Then we're going to do my completely unrealistic proposal. And then we're going to have some more reasonable advice for courts. Since this should be encouraging to all you law students who feel like you always get constrained by the doctrine, it's okay to come outside of it and be critical. You just got to back it up at the end with a little bit of doctrine. All right, so story time. Contraception matters in general and in this argument, and I think we probably all are cognizant of the facts and probably mostly normatively on the same page, but it matters in particular ways for this argument. So I'm just going to quickly show the scope is large, right? Millions of women need contraception, and cost is a barrier to access, particularly for a LARC is a long-acting reversible contraceptive like an IUD, which are favored by many women who, more women would use them if they could afford them, is what the studies show. So that's the need. The second kind of premise to be working with here is that law is expressive, right? It has both practical and expressive purposes and effects, so it's sort of 4 quadrants. And in the contraceptive context, this means the Supreme Court has long recognized that women's control over their reproductive lives is crucial to their economic and social equality. We've all heard that Casey versus Planned Parenthood quote. Therefore, the legal right to no-cost contraception not only ensures access to a practical benefit that women need, but it sends an important message about social and political commitment to women's equality. So it has both an expressive and a practical dimension. Zoom. Okay, so Jessica covered this quickly. Very quick refresher for the purpose of this argument. Insurance plans have to cover contraceptives at no cost. There's an exemption for basically churches, also mosques, synagogues, any house of worship. There's an accommodation for religiously affiliated organizations under which, I'm not sure if we talked about this already, under which the insurance company has to pay for the coverage. So the employees are supposed to get seamless coverage, although there's basically literally no enforcement mechanism. But the religiously affiliated organizations don't have to pay. The cost can't be passed through to the organization or the employees. So that's what we call the accommodation. The exemption is the churches who don't have to provide it at all. And then there's no exemption or accommodation for for-profit employers. And there have been, is it like 80-something now cases brought? And it's about half and half religiously affiliated organizations like Catholic hospitals, educational institutions, social service agencies, and then half for-profit employers, like Carolyn was talking about, like the arts and crafts stores, the Hobby Lobbies of the world. Okay, so this is the 2-minute Cliff Note version of free exercise law. So a religious exemption is when a person or an organization wants to be allowed to do something prohibited or exempted from doing something required for religious reasons. I know we're mostly lawyers, but we're not all lawyers, so I don't want people in the dark. All right, the First Amendment test under the Constitution. First question is the law neutral and generally applicable? If yes, go home, you don't have a claim. If no, you have to go to step 2. Does the law pass strict scrutiny? Is there a compelling state interest? Is the law narrowly tailored to achieve it? A side note, if you sat through your First Amendment class and you do not know what generally applicable and neutral mean, don't worry because nobody knows what that means. The best guess is that it means you can't be targeting religion, either in the passing of the law or in its application. So you can't be trying to discriminate against religion is kind of the best we can do on what the Supreme Court is talking about. All right, then there's a statutory claim under the Religious Freedom Restoration Act, right? And this is a more difficult for the state to defend against, easier for a plaintiff to get relief, most of the time. So there the questions are, is the state imposing a substantial burden on your free exercise? And you think the answer could be no sometimes, but that is a trick question because everything is a substantial burden according to the courts. So then you go to part, not everything. If you're a prisoner, there's no substantial burden. If you're not a prisoner, then there's a substantial burden. And go to strict scrutiny. Is there so this is where RFRA differs from the First Amendment in a way that matters later in the argument, which is why I'm talking about the boring law stuff. Is there a compelling state interest in applying the law to the plaintiff in question? So under the First Amendment, it's a little fuzzier, and it often seems like the state just has to have a compelling interest like public health. That is a compelling government interest. It exists up here at this level. Under RFRA, you have to have a compelling state interest in applying the law to the plaintiff in question, right? And that gets difficult because if an employer has 50 employees and the government says, well, our compelling interest is public health, then there's a scope and scale problem. Like, well, if you're trying to protect 50 million American women, is it really compelling for these 5? So that's a kind of a problem with RFRA that one of the things my argument attempts to address. And then, is the law narrowly tailored to achieve that compelling interest? As a side note, as I said, basically no one knows what free exercise is, so that's also a freebie. And same for substantial burden. So if you don't like it, then your burden is substantial. These are great paper topics if anybody, the literature is completely undeveloped on really what is free exercise, not undeveloped, but underdeveloped. What is free exercise? What is substantial burden? Carolyn's done some great work on these questions, but there's just not a lot of good theory out there about it because courts are scared of it and don't know what to do with it. All right, so recap. Plaintiff has to meet some threshold, which may be fairly difficult for the plaintiff to meet under the First Amendment, or pretty easy. Ridiculously easy could be an overstatement. Pretty easy under RFRA. And after that, the state has to satisfy strict scrutiny, which it will find easier to do under the First Amendment than under RFRA. Okay, so what's missing? So the usual story in all these cases is the state versus the sympathetic believer, right? And in those cases, the state's compelling interest is usually framed as being efficiently administering the law. So the classic case that many of you might have read is Sherbert versus Werner, in which the plaintiff was denied unemployment benefits because she wouldn't work on her Sabbath. And in that case, the courts, the state's interest was in efficiently administering its programs, right? This comes up in a lot of cases, the tax code, the unemployment insurance, whether they win or lose, that's the interest that they promote. Okay, and what I argue is that that really elides a whole set of cases which don't fit that model and which the doctrine doesn't really have a good way of understanding. I say hiding in plain sight, the existing rights holder. And the reason, even though it's not a very snazzy acronym, that I insist on calling it the existing rights holder is that I want to reframe the relationship in question, right? An existing rights holder is someone who already has a right to a benefit, a protection, a privilege that the law has already given them, right? There's a pre-existing relationship between that person or that group of people and the state. And it's actually the religious objector who's coming into the middle of that relationship. So we want to stop thinking about, this is my idea of visual interest, by the way. This little seesaw took me like 45 minutes. So it's not just state religious objector, up, down, but rather a triangle, because I could not figure out how to visually indicate like vectors of any kind. Oops, sorry, that's too far. So I don't mean triangle in any sense of who's on top or even that it's linear like that, but this is the best I could do. It's a kind of shifting set of vectors between existing rights holders, the state, and religious objectors. So to use the contraceptive coverage requirement as an example, sure, the state has an interest in promoting public health and access to contraception, and that would sort of fit on the seesaw. But our real concern here is the women whose access will be blocked by religious exemptions. Those are the existing rights holders. So as a side note, I think one reason this is important as a political or strategic matter as opposed to a doctrinal matter is that the religious believer seems very sympathetic. The state is this kind of faceless, oppressive thing that is coming in to crush the free religious exercise, right? So we need to make leverage the humanity of the individual's existing rights holders and show the state as being actually protective and supportive, right, in this way. So it changes also our sense of who has the power in the relationship and what they're using it to do. All right, so that's great for me to say. Does the Supreme Court care is the next question. And the answer is sort of. So I argue in the paper in more detail, the Supreme Court does care about the effects on third parties, it's kind of inchoate and it's not phrased the way I would phrase it. It's not necessarily part of the test. But you got to work with what you can get. And so these are just a couple of examples of ways in which I argue the Supreme Court has indicated a concern for these kind of third parties or existing rights holders that we can try to put together in a better way. So as a practical example, in Reynolds versus United States, the Supreme Court upheld a ban on polygamy despite a free exercise claim, which you can see how, for Mormons at the time, that is a much stronger free exercise claim than probably insurance coverage for contraceptions, right? Polygamy was a pretty core tenet. The Supreme Court strikes it down despite a religious freedom claim, partly in order to protect vulnerable women and children. The free exercise doctrine, this is over 100 years ago. It's not in the same form as it is now, so they're not applying the same test. But this is one of their concerns. Also Prince versus Massachusetts, which is not up on the screen, in which the Supreme Court upheld conviction under a child labor law for a woman who had her 9-year-old niece/ward proselytizing, selling pamphlets on the street. The Supreme Court said, no, child labor laws are more important, even though this is a core religious tenet of yours. So that's practical. The Supreme Court has also recognized expressive. Remember, we talked about the expressive impact of law. So in Bob Jones University, which is a super weird case, if you've not read Bob Jones, you should go read it. It's fascinating. Bob Jones University is a fundamentalist Christian university that initially had a racially discriminatory admissions policy, and then when that became not so okay, then they had a racially discriminatory dating and marriage policy. So you could go to the school, you just couldn't date anyone not in your race or marry them, then you would get expelled. So this is not that long ago, people. This is like the case I think is 70-something, 72 maybe. So the IRS revoked their tax-exempt status, and they challenged it. And the reasoning was that public sort of institutions, nonprofit institutions, have to kind of abide by national policy, basically. You can't be like so discriminatory and still get the benefits. And the Supreme Court held that the IRS was within its rights because racial equality and racial non-discrimination was such a core public policy value that the message sort of that it would send to allow Bob Jones to reap the benefits of the kind of nonprofit system and to be kind of validated in that way were unacceptable. This is not done in the sort of, I think one of the things that's actually interesting is that most of these cases don't fit the court doesn't do the exact kind of application of the doctrine, and I think that's because it doesn't really fit in. So there are these weird cases where the court just sort of says what the standard is, and then sort of applies it, and then like talks about something else that actually matters, like these interests. And then there's sort of hybrid cases like United States versus Lee, which Carolyn referred to, in which the Supreme Court held that the Amish have to pay Social Security taxes. And in that case, the court did do the kind of standard apply the test, and held that the state's interest in efficiently administering the Social Security system was paramount. But they also talked about how exempting the employers would make the non-Amish employees bear the burden of the employer's beliefs. It's another example. It doesn't really fit into the test, but they obviously think it's important. Okay, so how could we synthesize this? And why do we need to at all? Mind the gap. One, as I've said, the precedent is kind of spotty. Things aren't formulated into a test we could easily use. Some of the precedent is quite old, which, it's still good law, but, it's not that modern. And most importantly, as a conceptual matter, in the modern version of the doctrine, it's all or nothing, right? So the religious believer comes in and wants an exemption. The state tries to defend against the exemption. It's a zero-sum game. Either you're going to get your exemption, or the state's going to totally get to deny you your exemption, even if there's actually a compromise that would maybe be more rights-respecting overall, right? And given the fact that pretty much everybody agrees that religious accommodation law is just a matter of policy balancing, if we're going to have any free exercise rights, then they're going to come up against other interests, and we're going to have to draw the line somewhere, and you just have to start with a premise and start reasoning out to figure out where to draw that line. There isn't really, there's certainly doctrinal reasons that what I'm about to propose doesn't work, but there aren't really conceptual, legal, philosophical reasons why not. Okay, so my not so modest proposal, using the, it may be modest, it's just unrealistic, that wasn't really. Using the contraceptive coverage requirement. So I argue in the paper, and I'm happy to talk more about this in the Q&A if anybody cares, it's very condensed here, that the first question for a court looking at a free exercise claim, and again, I'm not arguing courts would actually do this. This is in the ideal world. Does anyone have a substantial interest at stake, right? So here we see, I think we all, not all, a lot of us would agree women have a substantial interest in accessing contraception for for the practical and the expressive reasons that I said. Do the religious objectors have a substantial interest? I mean, I personally don't think they do, and I think in the context of our current doctrine, there are good arguments about why they don't, which have been made by some of the people on this panel, that the connection is very attenuated between paying for insurance and people getting coverage, and also actually employers don't have to provide coverage at all. They don't have to provide health insurance, they can pay a tax instead, it's less than the health insurance. So there's a lot of good reasons there isn't a burden, there's a huge literature about this out there, people can look it up if they want. But for the sake of this argument, we're going to assume yes, because A, for better or worse, that's what the courts are tending to find. Knock on wood, but I don't think the Supreme Court is finding that there's no substantial burden. And also, then I would have to end my little plan at number one. We want to keep going. So let's assume they have a substantial burden. So then I argue that really the next question should be, can the state make everyone happy? Is there a solution that would be more rights respecting generally so that we wouldn't have to just pick all one or all the other? So in the contraceptive coverage requirement, this may be the most controversial statement in this room that I would make in this room. I think it's arguable that with appropriate enforcement and with seamless coverage, the accommodation that's being offered to religiously affiliated organizations, if it were offered to religious employers, would arguably be an acceptable accommodation. I think there are costs to that. I think there are expressive costs to it and symbolic costs. I'm not in love with it, enthralled with it, but I do think it's arguable that that would be acceptable. However, it doesn't matter because the for-profit companies would reject it, right? So it's not actually a compromise because they're not interested in compromise. And I think we know that because all the religiously affiliated organizations are suing to challenge it. So it sort of doesn't matter. And I think even if this system were a reality, we would have the same outcome, which is that you would see that sort of religious believers, religious objectors are really trying to create enclaves with kind of no secular authority over these questions. And so they actually wouldn't be particularly interested in compromises that would make both sides happy. And so then the third step would be that if there's no way for the state to make everyone happy, but there are substantial interests on both sides, then equality implicating rights should take precedence. And if there is a conflict between equality implicating rights, which is what the religious believers here would argue, right, and that all depends on how you frame it. Is it your religious interest in moving in the world as a religious person, or is it in providing contraceptive coverage that may or may not be used, right? It's all framing. But they would frame it as equality implicating. Then this government should be, as it is now, empowered to choose one set of competing rights over another. If we have a set of equality implicating rights that are equal in that sense, then on some level that's just how the democratic process works, and the state should be allowed to pick one, which it has. Okay, so that's never going to happen. So here are a few things that I think this analysis, though, suggests about the current doctrine that would help courts better understand what's going on. So the first one under the First Amendment is that general applicability is a framing analysis. I don't think that's how courts understand it, but it's how they should understand it. So under general applicability, as you recall back in the 10 minutes ago in this presentation, when you're doing the First Amendment analysis, the first question is the law neutral and generally applicable? And one of the big parts of the analysis is you look at whether there are other exceptions in the law. If the government has carved out lots of exceptions, then it's considered not generally applicable, and the state doesn't have a convincing reason why this religious objector can't have an exception also if all these other people have gotten exceptions for other reasons. So the plaintiffs, I think, make several sort of misleading statements about what the other exceptions are. But I'm trying to do this very briefly. The correct frame is that only churches, basically, are exempted from providing contraceptives even if they provide insurance coverage. Everybody else has to provide contraceptives if they provide insurance coverage. That is actually the frame of general applicability, and so there are many fewer exemptions than actually appear. And general applicability also needs to take into account both practical and expressive impacts, right? And so exemptions may not have the same expressive impact depending on who they exempt and why. And so the state's sort of expressive purpose may in fact not be undermined by certain sets of exemptions, where it would be undermined by giving exemption to a religious objective. And under RFRA, I focus on the strict scrutiny test, which is also part of the First Amendment, but it's harder under RFRA. So one thing the court should understand is that compelling interest should be understood to operate on an individual level, not just a large-scale social level. So when the government has passed a law conferring a right or a benefit on an individual or set of individuals, they have a compelling interest in preserving that right or benefit for those individuals, right? And this helps you with the narrow tailoring analysis under RFRA. Because as I said before, if public health is the goal and there's 50 million women who will be helped by the law, and this employer, you know, I mean, Hobby Lobby is a lot, but Conestoga has like 50 or something. There are a lot of smaller employers. It's hard for the state to argue that it has a compelling interest in making that plaintiff follow the law. But if we understand that the state has conferred kind of vested interests on particular individuals, we can better understand. And then the last thing I will say is that that tailoring may be narrow with respect to expressive goals, even if not practical ones. And so when you do the narrow tailoring analysis, right, the plaintiffs can say, well, you could have done X, Y, or Z that would have been more respecting of our religious rights and still would have promoted your agenda, and then the state has to respond with why those were not feasible, and then the court just kind of decides whether it thinks that's convincing. I mean, another place that could use more scholarship on what on earth is going on with the tailoring analysis. So I think if we think about the state as having expressive goals, then some of the kind of proposals that a plaintiff might make, although they might have been more narrowly tailored practically, would undermine the state's expressive goal and therefore would not be narrowly tailored. Okay, so that's that. And I'm happy to take questions about any of that, and I hope nobody's nauseous after all that zooming.
Thank you very much, panel. That was very, very interesting from my perspective as a non-lawyer, as I've said. I have one suggestion for Cara. Instead of calling them existing rights holders, maybe you could call them holders of existing rights, and then the acronym would be HER.
Nice. See, this is why you got to go outside the law. I consulted so many people. I got no good acronyms.
So now we do have some time for some questions. Would anyone like to start us off with a question for it? Identify which panelist you would like to address a question to. Dr. Anderson in the back.
Well, thank you all for coming. Very insightful panel, and bright people can teach you things you don't know. I had a question for Professor Corbin. I fully agree with the differences between corporations and human beings that you laid out. One of the challenges for dealing with corporate rights is that when corporations began, if you go back to King James or even his mother, in England, I mean, in Europe also, religious organizations ran governments. And so they engaged in all kinds of nefarious things like the slave trade, or some of the governments didn't recognize women as equals in property rights and various things like that. So I'm just wondering if in the conversations, both in the scholarship and in the courts, do we do something about the strange history of how corporations came about and how they seem to be strengthening in their rights as opposed to having their rights scrutinized, because they've been kind of entangled in sort of the whole capitalist model of how we do things, both public and private. So I just kind of throw that out because it's always intrigued me that we haven't reflected on the history of how they came about, and maybe that's why they're so strong in the law, even though they're simply not comparable to human beings.
There are all kinds of things you could say about the growing power of corporations, and I think the very fact that they're claiming to have religious rights would not have occurred earlier and hadn't occurred. I thought what you were going to say, I thought your argument was going to be, churches have done a really problematic things. Why are we granting all these rights to churches? Which, I'm like, never mind corporations. Yeah, so I think, yeah, that's true. I actually don't think, I actually am a proponent that churches only have rights to the extent their individual members have rights. And the Hosanna Tabor case was an interesting example because usually those two things are pointing in the same direction. And the Hosanna Tabor case was an example where you had a religious entity claiming rights against one of its individual members. And there you had the entity prevailing over the individual, which I think is highly problematic in itself, which doesn't answer your question, but I thought I'd mention it.
We stultified you all into submission.
I'm sure a student would like to,
want to thank all the panelists because I thought all the stuff was really great, and it has a lot to do with the things I've been trying to think and write about. I want, Cara, your discussion at the end kind of made me think of this quote from Justice Kennedy during the oral arguments in NFIB. And I realize he's talking about the Commerce Clause, but it really seems to kind of resonate in what we've been talking about today. And so he asked the question, I understand that we must presume laws are constitutional, but even so, when you're changing the relation of the individual to the government in this, what I think we can stipulate is a unique way, do you not have a heavy burden of justification to show authorization under the Constitution? Isn't this notion of, oh yeah, you have rights against being discriminated, rights to be free from discrimination, but we're going to, we've enacted this program that, tries to put into effect that right to not suffer discrimination in access to preventive care. But now someone wants to change that relationship between the individual and the government.
Yeah, that's a great comment, and that's really helpful. Thanks. And I wish this paper was not already in production. But yes, I think that's right. And I think really as a total legal realist leaving aside the doctrine, right, what's going on is that there are certain rights that we would enforce, like the right against racial discrimination, which we have decided culturally is basically inviolable in this context, and we are not there with women with sort of reproductive rights and sexual rights, right? And so there's this very strong kind of normative sense going on that when the government confers a right or benefit on you, there are some that we value more than others. And so, and unfortunately Kennedy may be on that dominant track and not so much on our track. But I think that's one of the core problems, right? I mean, there's really, I don't think there's any really principled difference between racial opposition to desegregation and racial opposition to sexual and reproductive equality. But as a cultural matter, the way those claims read is not equal yet. And so part of the project really is just moving the priority on sexual and reproductive and gender rights up the cultural hierarchy until we understand that they should read at the same level.
I actually think that it's not an accident that these novel claims about corporations' rights to religious exemptions have arisen in the context of reproductive rights, because as we see time and time again, the rules are just different when it comes to women and their reproductive rights. And so if this were a Jehovah's Witness challenging the coverage of blood transfusions, I do not think these cases would have gotten nearly as far as they have. I have just one point about the sort of the other stakeholder, which we haven't mentioned, which is sort of interesting, is there is a question about whether or not granting an exemption might violate the Establishment Clause. So you probably encountered there, but we've been focusing on the Free Exercise Clause, but there are some limits to free exercise exemptions that you can find in the Religion Clause jurisprudence. And one of them is if you do impose too much burden on a third party, or I should say a existing rights holder, then it does raise questions about whether that violates the Establishment Clause.
Yeah, I think that's a great point, and there's a lot of really vibrant academic discourse going on around that right now, which I think is super interesting. I don't focus on that in my paper, and one of the reasons is that I think it's good to have an argument within. So the Establishment Clause argument basically takes you down a road where you have to say that RFRA is kind of unconstitutional, and so, I mean, people argue. I think people argue.
I don't think you don't have to go that far, because you can argue in general it's
right,
constitutional
at least in this
particular.
But in any case, yes, right? So, and I think that's a good argument. I do think there's also sort of value to having an argument that operates just within the kind of statutory structure. Unfortunately, I don't think the courts are going to take either of those. But yeah, but so I think yes, the Establishment Clause is a really interesting place to go as well.
I just want to pick up on your point that if it's not an accident that it's happening in this context, right? And I think that's sort of what I'm trying to get at. We conflate morality and gender and reproduction in a way that we don't conflate other things, right? You can't see an employer saying, you have to, in your contract, agree that you give up your right to vote, right? But essentially we have employers saying you have to, because of your contract, agree to give up your right to become pregnant, right? And we're seeing that same sort of thing because we allow in the discourse, right, the conflation of the two, and we allow this framing of, well, it's a moral issue and a religious issue of whether you're going to become pregnant and when and how you're going to become pregnant, then suddenly we're not talking about the gender issues and the fundamental right issues, right? So I think you're absolutely right.
In fact, one of the early cases against the ACA was an corporation, right, claiming that they had an objection to providing health care coverage at all, right? And the courts just had like no patience with that. That was just like, that's ridiculous, go home or pay the tax, whatever. So when it's sort of that broad-based, the courts aren't even taking it seriously, but yet, right, when it comes to reproduction, all of a sudden it's like the most compelling religious interest that we really have to deal with.
And just one further irony. There's so many things about these cases that are just stunning, is that Hobby Lobby's objection is not actually to contraception. Its objection is to morning after pills, Plan B and Ella. Yeah. So they're okay with contraception. Their problem was with abortion. And they're saying they don't want to cover these medicines because they act as abortifacients. But they don't. They're not abortifacients, right? The scientific evidence is in. They prevent ovulation. So even under their erroneous definition of when pregnancy starts, which is another question, right? If their concern is about killing fertilized eggs, there are no fertilized eggs that are affected by Plan B and Ella. There are no fertilized eggs because Plan B and Ella prevent ovulation. There are no eggs. And it's extraordinary to me that the courts have allowed claims that have no scientific basis in fact to go forward. And again, I think if we were in another media and someone said, well, we don't want to cover these medicines because they contain, animal byproducts and that's against our religion, and you had a brief saying, right, there are no animal byproducts in this, I don't think courts would just ignore that and say, well, let's just ignore the science and assume that they do what they don't actually do, and let's hear these cases about how this is such a tremendous burden on your religion, even though there's actually no conflict between your legal obligations and your religious beliefs.
Right, we're all fascinated with this topic, but that's also, this is part of that problem with defining exercise, right? There's this sense in which your religious belief about how a contraceptive method works is somehow, not a scientific question, it's a religious belief.
Well, it's accepted because it's asserted as a religious belief.
Right.
There's a blind
Our poor
acceptance.
moderator wants us to let people ask questions.
We could talk about this for a very long time. But it is my job to end the panel, and I'd like to thank all of you for such great presentation.
Go to Corbin, I'm going to clear this all up for everybody right now. We can't just all go home.
You can, at least Hobby Lobby.